Well, hello everybody. Welcome to another Coffee with Michael. I have the wonderful and talented Brad Barbagallo. I got to get that B and B together. Brad Barbagallo. He's been on a Coffee with Michael before, one of our podcasts. Did a great job, and I just have to have him back. Real briefly on this. Brad is from Roxborough, Pomerantz, Nye, and Adriani. From now on, affectionately referred to as RPNA, because the other one is just a mouthful. Brad's practice areas include employment issues, insurance, bad faith and coverage disputes, subrogation, workers' compensation, personal injury, medical and professional malpractice, general business litigation, breach of contract, and data privacy. Brad has experience as both plaintiff and defense counsel, so he was one of the bad guys before he came over to our side, as well as experience working as a private subrogation counsel for one of the largest workers' comp insurers in California. I mean, absolutely wonderful experience. Brad, good morning. Actually, good afternoon now. How you doing?
Good, Michael. Thank you so much for having me on. It's good to be back. I appreciate it.
No, it's fun to have you. And so we have three topics. And I know I always say I'm excited about these things when I get to do webinars or these podcasts with some great attorneys. But this one is really fun. We have three different topics. They're different, but they're fairly similar, kind of in the same realm. But it was funny because one of the topics that we're going to get to when I emailed Brad said, "Hey, I know we already have some things on this topic. Can we throw this in there too?" The first word on his response was "oof," because what we're going to talk about is complicated. So before we go anywhere, I want to make sure that everybody understands. Even though I have an outstanding attorney with me, nothing here is to be considered legal advice, right? This is just two guys getting together, just talking about some stuff with some good information. But if you need help, specific help for your organization on anything, please refer to the email where you got this link because all Brad's information will be there. And I encourage you to reach out to him or his team, and they'll get some help for you. So today's topics, again, three different issues. We're going to talk about remote work to begin with. Then we're going to go into a new EEOC position on bias. I sent out the press release from the EEOC, I believe it was last week on one of my HR alerts. And then the new one that I got the oof from was a new current immigration requirement for certain individuals. It's new, but it's not really new, and we're going to kind of go into there. Um, so the first thing, let's pick off remote work first. Um, there has been a lot going on with remote work, especially the last year. Once COVID kind of ran its course, we had a lot of remote workers. People are needing to come back. Employers have been trying to get them back. Some have been really good. Some of the employees have been great about coming back. Some of them haven't. And now with this whole Doge thing going on federally, there are lawsuits out there. And I thought it would be important to talk with you, Brad, about this because from a remote work perspective, what can employers do now and what should they be doing? Because they've let people go out and trying to corral them back in is a real fight for a lot of people. So what are your thoughts on remote work and bringing people back?
Sure. Yeah, it's a very good question. Very difficult topic for a lot of employers right now. I want to start out with a first kind of level setting, which is there is no entitlement for an employee to work from home unless that is in some type of employment contract. But the law does not provide that as some type of guaranteed entitlement. Rather, working from home is a benefit. That is what it is construed as. Um, the pandemic put it in the forefront and when everyone had to do it. But there was remote work before, and there continues to be remote work after, because a lot of employers have found employees really like it. It adds work-life balance, flexibility, some different levels of control to their job that maybe they don't initially get. And so I think there's a lot of positives, and it's why I think there's a lot of resistance to now employees going back. So the next step is for employers is how do we do, how do we do this? What should we be thinking about? Well, the first thing I want employers to know is you have legitimate reasons for bringing people back.
Mhm.
So there's studies that have come out that having in-office days can be positive for the work experience, including new hires. It's shown that new hires will end up staying on a job longer if they have a better onboarding process. And many new hires feel a remote onboarding process doesn't get them linked up with the company culture. They have a hard time getting to know their peers, their boss, things like that, and it can be difficult for them. It also can really be detrimental to teamwork, cohesion, collaboration, just the entire flow of the workplace and the culture that you're creating. So a lot of employers are wanting to bring employees back. And then the last thing, and you mentioned it with Doge, is efficiency.
Mhm.
Work from home came out of the pandemic as a necessity. We have to continue. We need to continue to do our jobs, but no one can go anywhere. So we got to make this work available remotely. It has come forward with a lot of different studies that workers who work 5 days a week from home are less productive than their peers in the office. There's tons of reasons for that, and people always make the jokes that you can make a statistic for anything, right?
Yeah.
But I think what my initial comments are is it's complicated. There's two sides to this coin, and employers need to kind of, thread the needle a little bit to balance keeping their employees happy and having a productive workforce with doing what's best for the company in terms of developing a company culture and helping people reach their fullest potential. So I go back to is it's really important that you have a work from home policy. If you have work from home at all, you have to have a policy. There needs to be requirements. There needs to be communication structure. There needs to be an understanding of expenses and things like that. You also need to make sure that your work from home policy lines up with your employee handbook and your general policies and practices. So you have an anti-discrimination policy. Everyone should, right? And so you need to make sure that in implementing any type of work from home policy, you are not running afoul of any type of other discrimination, national origin, or other issue that may be out there within your company. And one of the ways is you don't want to be cherry picking and only allowing a few employees to work from home or things like that. Those are areas that can get you in trouble. So really make sure you have a solid work from home policy for anyone that works from home. It will also give you the ability, it can be almost a PIP in a sense, a performance plan, in that it can allow you tools to bring your employee back if they're not meeting certain performance criteria.
Mhm.
And a policy, a good work from home policy, will allow the employer the latitude to do that and create legitimate business reasons to bring someone back as well. So definitely want to have a good policy, and that's something to focus on.
Yeah,
Um,
I'm sorry.
but I was gonna say, I was like the only other thing I wanted to add there was if you do bring an employee back or ask them to come back and they say no,
Mhm.
that's the other piece that you want to start looking at and say, well, why? What
Yeah.
is the reason that they don't want to come back? And it doesn't need to be these are the only reasons that are approved. It should be why do you not want to come back? And then you can ask them, are they trying to make a request for a reasonable accommodation? Is there some type of disability issue that you're missing? Or is this truly just their preference? And if it's just their preference, now you know and you can make your legitimate business decision based on that and saying, look, I understand it's your preference, but we are requiring all employees to come back. And therefore, if you don't want to do that, it would be a condition of your employment and we would take that as your resignation. So you can only do that though if you walk through the process and give them the opportunity to advise you of some type of disability or need for reasonable accommodation.
So let's get into the reasonable accommodation real quick. Would be if you're having conversations with the employee and they think, well, I'm seeing a doctor, and a lot of people are applying this to mental health, right? I still
Right.
anxiety coming in. That's fine, but employers sometimes are hesitant in asking for a doctor's note. But that's the first thing, right? Is say, hey, we're so sorry you're dealing with this right now, but what we need to do is to be consistent in our process. We need to make sure that we have a doctor's note, which may list any restrictions you have for your job, so we can make sure we are making the proper accommodation if we're able to. So at that point, then the employee and you give them what, a week, 2 weeks to get a doctor's note if they
Yeah.
choose.
Totally. Yeah, and
Okay.
that's a great and that's should be part of your policies as well, right?
Yeah.
It's a great thing to do because then you can hide behind the policy, right? Hey, I'm so sorry to hear that you're going through that. as part of our policy, please, at your earliest convenience, can you talk to your doctor and get us the note that says what's going on and what type of work restrictions are? That starts the reasonable accommodation process. The conversation that the law is looking for, that will allow that conversation to take place, and it will give you protection because it's the second piece of it that is usually the issue. It's the mental health piece. You get the doctor's note, and the doctor says, yes, they cannot go into the office. Okay, well, now you can start working with them to establish if they can continue even working for you anymore. And I've had that with mental health where this individual, in order for her to come back, she had to work with people that was, severely impacting her mental health. A
No.
boss, a coworker, whatever is giving her, stress. But she was only qualified to work in that department. So the work restriction said you're too stressed to work with these people. Well, you're not qualified to work anywhere else. And now it allowed the time for her to have a conversation with us. We walked through and said, hey, you're only qualified to go back to this group that you don't want to go back to. And I don't want to put you as the employer in a position where you'll get hurt more. I'm trying to protect you.
Right.
And so I can't put you there. What do you want to do? Is there any other position you believe you're qualified in the company? A lot of times they said no, and that employee ended up resigning on her own without a severance.
So
So
what you're talking about though is an essential function. I never even thought about in this way, but an essential function is, well, you have to be able to deal with your manager because that's the only manager you're going to have. There's no interim, right? Individual. So I
it,
never
it
even thought about
certainly,
that
yeah, it
being,
certainly allows legitimacy for the process. I
yeah,
think people don't understand that work restrictions are restrictions, but for both people.
yeah,
Employee and employer. We only see it as employer. Oh, the employee is restricted to this. But it does go the other way. It does limit the employee. And by
yeah.
limiting the employee, one of the requirements through the ADA and reasonable accommodation is qualification. And if you're not qualified based because the work restrictions have made you unqualified, now the employer is on better footing. So it's a process, but you need to use the law in the way it's written, and that's the one of the ways to use it.
Yeah. And so the last thing here before we go on to the next topic is you brought up earlier about cherry picking, right? These employees can work from remotely, but these can't. It is legal to have different positions available for remote, right? So you can tell a machinist, yeah, you can't work remotely because you don't have the machine at home. However, somebody in a more administrative type position that would have access to the internet and the phone and all that, within a certain department, you cannot cherry pick, right? If you're saying, okay, this is available, then you're looking at the metrics that are set up. Are you still in good standing? Have we been writing you up for performance already? Productivity, things like that. But if not, then anybody should still have that same ability to go out. So one of the things you need to think about is, can we afford an entire department to go remote if we offer this? Because we can't say, well, half of you can, half of you can't, unless you're on a rotation, right? This week, 3 employees get to go. Next week, the other 3 get to go, and then you go back and forth. But other than that, you've got to be very specific about who goes and when they go. But not everybody needs to be allowed. Not every department needs to be allowed.
Correct. And one of the ways I've seen it is, and in my experience was, I worked at a large publicly traded company that had two facilities. One was corporate and one was the labor side, the pack
Yeah.
house. It corporate had a lot of different, aspects of it. It was administrative, people are at their desks, computers, things like that. Work from home was a potential there on a rotating schedule. Whereas all the labor force that has to come in physically to pack the fruit is over there. They were not able to work from home as part of the job. So we were able to have the workforce split up into two basically categories. Now, where we had an issue over on the corporate side was within one department, no one could work from home except for there was one employee who had been able to work from home for years and it just kept going. And that created problems. It created jealousy, it created, ideas of discrimination, favoritism, things like that. And we started getting complaints, issues, whatever. And that's when you start hearing oh, well, she gets to do this because of this, or I don't get to do this because of insert protected characteristic, right? Now you're in dangerous land. So what I say is you can allow employees to work from home as a benefit to the company, so long as I would say have a solid policy. But if you are going to be giving it on an ad hoc basis and picking and choosing employees, I find that there will be a lot of risk and claims that will come after that, and you might be putting yourself into exposure that is unnecessary.
What about grandfathering in something? So if you have current employees that say, okay, look, we're going to be changing the remote work policy going forward. So all new employees will not be able to do it, but we're going to grandfather it in where employees earlier than this date, you have a red line, will still be able to access that remote work. So you can kind of, you're hiring people that know that that's not available for them, but your current employees, you can still retain that expertise and experience. Is that something that's permissible to do as long as you put it in writing and say, okay, this is the day?
Um, it's permissible, but I do think it still opens you up to
Causes
problems.
problems.
Yeah,
Yeah.
I'd say I'd also still say if you have long-term employees that don't want to return to work, and we had that, I've dealt with that a lot, and a lot of them, um, what ended up happening or what was an option was severance, and
Okay.
where we worked with them and said, look, we don't want to lose you, but we do have to bring you back. And I understand that you've been here for a long time and that this is where you're comfortable doing, and we do feel, we feel for you. So this is what we're willing to do. You can come back with your full job and everything, and it's all great. Or we can offer you this, what do you want to do? And that was a much better conversation than like, no, you have to come back. And then it was
Yeah.
this hostile, thing. Um, Sometimes you can broker a deal with them too. Okay, well, let's do 2 days a week
Yeah.
for
That's
the
actually
first six
worked out well
months.
in a few places. Yeah.
Right, 2 days a week for the first 6 months or a year, but in 12 months, you're back full time. Or, the whole company is rotating to a 1 day a week work from home, and, we'll allow you to kind of get yourself into the office over 12 months, and finally in 12 months you'll be held to that standard. Things like that I think you can do, but there should be an end date on it.
Yeah.
Eventually, you are going to be treated like the entire employee population. So maybe give them 12 months, but that way you can actually defend the policy that it's not open-ended and you're not discriminating. You can say, no, this is based on seniority and a benefit that we were giving this individual employee, but there was an end date on it.
And I got to tell you, the 12-month, it's a lot of people would balk at that saying, oh God, that's so long, and it is generous, but boy, you sure look good giving them that much time to get back into the office. So,
100. That's the great point. From the defense lawyer side, as
yeah,
the trial attorney that has to try your cases too, I like that story a lot better, right? We didn't
yeah.
force you into anything. This is a job that you signed up for, and we have requirements. We bent over backwards to help you. So, you can't say that we didn't.
Okay, so the next one, this has to do with an EEOC kind of change in their position on certain things. It was a very interesting press release, and for those of you who got this email, hopefully you got the one I sent out last week on this. So the heading was EEOC acting chair vows to protect American workers from anti-American bias, and this is really interesting because all it's saying is, and again, this is having to do with the new administration. This was that, look, they feel that Americans were not, I don't know if targeting would be a good word, but they were not really reaping the benefits that they should have been having because they were getting lower paid workers. And so now this anti-American worker bias is clicking in. But it's not, the way I read this, it's not just people who were born here in the US. It's people who are here legally, anybody, right? There was anti worker bias from that standpoint because if you're here legally and you have all the paperwork, then you'd be getting, all the labor codes apply to you, all these things. It's not, you can't be, under the table for a few bucks less type of a thing. So I'm really anxious to hear what your thought on this was, and what kind of problems might be occurring for employers, and where should they look?
Yeah, I will say from a historical perspective of what the EEOC usually is focusing on, this was very new.
Yeah, this is not it.
Right. So what they are doing is they are enforcing Title VII that's on the books as it is, that
Yeah,
says you as an employer cannot discriminate against someone based on their national origin.
yeah,
It was always, though, and I don't say always, I mean, it has been historically prosecuted by the EEOC as an anti-immigration issue,
yeah.
where employers and people are treating immigrants wrong or not giving them jobs or not treating them fairly or not paying them the right wages, those kind of things. For example, oh, you're paying an American worker $10 an hour, 15 bucks an hour, and you're paying someone who is not an American worker, maybe not legal, $5 less, right? This did flip it on its ear to say, look, we are going after national origin discrimination, but in reverse. If you discriminate based on someone being an American citizen because now you have to give them more benefits, a higher wage, or they are more in tune with the government and the laws and things like that. Now EEOC could come after you as an employer for that. So, one of the things that they wrote this list that was really interesting that they wrote lower cost of labor, and it says, whether due to payment under the table to illegal aliens or exploiting rules regarding certain visa holders, a workforce that is perceived as more easily exploited, customer or client preference, and biased perceptions that foreign workers are more productive. So, ironically, the EEOC has really honed in on what historically are positives for workers that are not U.S. based through the H-2A, H-1B, those different programs where employers looked to some of these work programs because they could either provide a lower wage, or the individuals that were coming were very focused. They had really good productivity. They were only here for a couple months and whatever. And so there were a lot of reasons why employers leaned in to these very legitimate and legal programs that allowed them to work with, non-American citizens. I do think the EEOC's statement here is a lot of that. It's a statement. I will be very curious to see how they go about establishing worker employers who are not, I guess, hiring American workers and doing so discriminatorily. It'll be very difficult in my mind to establish that outside of some specific policy from an employer that says, "Hey, I only want to hire this insert country or this type of person, or I only want to hire non-American citizens for this job." Outside of that, I do think it'll be difficult as if the employer has a legitimate I-9 process. There's nothing illegal about employing someone who's here and is eligible to work.
Yeah, and it's interesting. Just yesterday, I was reading an article, and there was a case that went up to the U.S. Supreme Court on discrimination, and I'm not going to get into all the details of the case, but what I think everybody was saying on that court was that being part of the majority does not give you less rights than being part of the minority. Because a straight white woman was bringing a case of discrimination, and the lower courts were expecting her to show more harm, I guess, than they would if it was reversed. And the U.S. Supreme Court said, no, we're looking at Title VII, and there is nothing that says just because you're part of the majority means that you have to have a higher threshold to clear before discrimination can be found. So they are really looking at leveling everything and saying, no, guys, we're coming back to the letter of the law now, which is it's great for employers because now we look at the law and we follow the law, right? It's back to basics. Just follow the
Right. And,
darn
and I
law.
think if you want to read the tea leaves from what the EEOC is saying is
Yeah.
you hire workers based on qualification, right?
Yeah.
Legitimate business reasons. Are you the best person of this group of applicants to do this job?
Yeah.
Make sure that your applicant pool is diverse, and do your best to do that. And then once you have individuals that you are ready to hire, make sure you have a solid I-9 process, right? You can defend against a charge from the EEOC on this and saying, look, no, we wanted the best person possible. And that's who we got. There was no bias for it. And this person's legally authorized to work in the United States. So that's the number one thing. The EEOC speaks about illegal immigration and people who are working illegally, but employers that are following the I-9 requirements do not have individuals working for them that do not have work authorization.
Hmm.
Or if they do, they are unaware of it because they've provided fraudulent documents as part of the I-9 process. So every worker should go through the I-9 process within their first day of work, and the employers have 3 days thereafter to confirm the genuineness of the documents. So that is still remains the number one piece and the number one important, issue here for employers to protect themselves.
Okay, which is going to take us to part three, which is again very, very similar. This is the old but now new alien registration requirement. Um, and I'm just going to let you jump in on that, and you can talk about what it is and your thoughts on it. This, and just for the record, this is the one I emailed them and said, "Hey, can we do this one too?" And that's where I got the oof, because this is going to be a tough one. So
Yeah, very much an oof for this one. I'll be
yeah,
totally honest on it. To cover it, so on January 20th, the current administration came out with the Protecting the American People Against Invasion of Executive Order. I think effective date is technically February 25th, and so we're just starting it. Um, of the Immigration and Nationality Act, there's Section 262, and it requires all aliens 14 years or older who have not been fingerprinted or registered when applying for a visa to apply for registration and fingerprinting within 30 days. So anyone in the United States that is 14 years or older under this executive order is required to apply through USCIS for registration and fingerprinting. However, registration and fingerprinting, importantly, do not provide the individual with immigration status or an authorization to work. Further, if you do not register and you are found to not have registered, you can be subject to criminal and civil penalties. So, in reviewing the executive order, the first question that you and I discussed was what, from an employer standpoint, is the obligation here?
yeah,
Is there an obligation here, right? Threshold question. Is there an obligation? What do I do with this if I'm an employer? And my thought is this, and it kind of dovetails into exactly what I was just saying, is employers are required to employ only individuals that are eligible to work in the United States. That is the rule. Every person, if you're an employer that's working for you, should have some form of employment authorization that's been approved, whether they're a citizen and they have citizenship, or they have a work visa, or there's some other, mechanism within the government that's allowing them to work. Okay. So you as an employer, in theory, should not have anyone that needs to register. Okay. And just as a concept is to lay it out is you in theory should not have anyone that needs to register. So my feeling is no, I wouldn't say an employer should post this in a job site. Um, However, what the reality is one of the ways that the government can go about establishing compliance with this, low-hanging fruit is with employers. They can go into large employment settings and audit the I-9 documents and go through the workforce and see if there are people that are working there illegally. And if they feel as though the employer has not done the appropriate job to vet them, make sure the I-9 documents are genuine, keep the documents active, do recertification or re-verifications if the visas that they had now expired. If those aspects are missing and the government knocks on your door, then employer can be found, liable for different aspects of different laws here. You have requirements, and so uh, the Immigration Nationality Act does put a lot for the employer to say, hey, make sure that your I-9 verification process is tight, because at the end of the day, you shouldn't have anyone who's working for you that's working here illegally, or if they're working for you here illegally in theory, they've presented you with fraudulent documents that you believed were genuine at the time. And then you have a good faith defense for the government to say, look, I looked at these documents, they looked genuine. That is my obligation as employer to do it. If they are here and you found out something else, I appreciate you helping me.
And it's important. So you brought it up, and I wanted to make sure I reiterated this. There are a lot of individuals that will come and they're legal to work when they first get here, but their documents that they use are only good for a certain amount of time. So once they expire, it is always it's the employee's responsibility to make sure they have updated information to you before that initial stuff requires. But we all know that doesn't happen. It
Right.
just kind of goes out, and the employee may have updated their information, but they just never bring in new stuff for you. So make sure you do as part of the I-9 process. It's not just initially getting that information. It is, some kind of put something on your calendar that every so often you're going back and reviewing all these individuals that need to have information updated, because that could work against you at that point. They were legally here to work, but now they're not, and that could be a big
Right. And,
part.
and that's why Section 3 is in Form
Yeah,
I-9, right?
yeah.
Section 1 is the employee section, first day. Section 2 is employers got to complete within 3 days. And Section 3 is for the re-verification. So it's there. It's a real thing. I think the way we're going to be seeing, and what I've been talking with a lot of my clients about what should we be doing, is the best thing we can say is we do not know where the EEOC or these executive orders are going to go. It's a very fluid environment over the last, 30, 60, 90 days. So really focus on your I-9 process. Make sure you've audited it. Make sure you've done recent training. Make sure you feel confident that if you get an inquiry into that process, that you say, hey, I can stand up to this and I can defend myself. So that's definitely one thing to do. And I just want to share one story of why this is so fluid and why I am saying for employers to really focus on the I-9 was about a month and a half ago, there was a lot of immigration enforcement action in Kern County, which is a very big county in California for a lot of different crops. That caused a ripple effect throughout a lot of the different farming communities in terms of individuals showing up for work, being concerned about whether or not this was going to happen on farms and things like that. Since that initial raid, there hasn't been another one that we've found out about. So we're not sure whether you will get these directives, the level of follow-up locally that will happen. Or if there is some action, we're not sure if it's just a message sender
Mhm.
where they're trying to do some action to really more send a message than actually say we're going to start doing this on a granular level to every employer. So because we don't know the level of enforcement, I'd say the number one thing is be proactive internally. Look at your own documents. Make sure you can defend your process. And I would avoid making any assurances to your employees at this time without knowing where the current administration is going.
Yeah. And in fact, I have worked with a number of restaurants and manufacturers, and I've had a few calls since I started again promoting that we're going to be coming out. We're actually going to be rating employers because we want to make sure they're doing everything correct. We've had employees, because it's all over the news. Employees have been going to HR saying, "Is our job in jeopardy?" And the response has always been, "Look, if you are here legally and we have all the correct information, which we believe we do, they're not looking for someone like that. It's people who just don't have the correct proof
Right.
to show." And so again, there's so much bad information out there that people thought, well, I'm here legally. Am I going to get caught up in it? they may have questions about something, but you answer the questions, you show the paperwork, you should be fine. So please make sure that you're putting people's minds at rest if it comes to you. I certainly wouldn't go out posting things and making a big deal of yourself. But if individuals come to you, don't shy away from having that conversation with them.
Yeah, but stick to, like you said, Michael, stick to we as the company, we always want to protect our workers. And all of our workers are workers that have passed the I-9 process. So
Yeah.
we feel as though all of our workers are protected. And if the government comes, you open your door.
Yeah.
And you say, because, which is another thing we've talked about is, and I dealt with this a lot in one of my former positions where we were involved in a lot of different border issues in terms of bringing products back and forth on the US border. There's a lot of issues with illegal aliens getting into the trucks, drugs getting into the trucks, things like that. And the reality is if you do not cooperate with the government, they can make your life very difficult in other ways and other types of investigations. And the reality is most of it, most employers are not going to sit there in front of a employee entrance only door looking at an ICE agent saying, no, you can't come in here, right? So the reality is you as an employer have to look out for your employees. And the way you do that is by making sure your I-9 verification process is legit, because that's how you protect your business and that's how you keep all your legitimate employees employed and working.
I did hear about years ago. I heard about an employer that I showed up to do an I-9 audit, and the owner, yeah, blocked them and says, "No, you're not allowed here." So they said, "Okay, no problem." They went out to their car, got their guns, they came in and they got what they needed. So, yeah, it's
Yeah,
gonna.
I just I'd say you really just in a practical world, um, you really have to consider the business costs to not cooperating with the government. It's always a case by case, and I can't paint a broad brush. That's usually the time where I'm like, yeah, definitely call me.
Yeah.
But yeah, it's cooperation in my experience tends to be the way to go, um, especially when you feel as though you haven't done anything wrong. Okay.
And they're going to dig so much deeper if you give them a bad time. So yeah, stay away from that. All right. I think this was an oof. This is a lot. Brad, thank you so very much. I appreciate you joining us today. And then I've already talked to Brad, and we're going to continue talking. We have so many other topics that he's
Yeah, a
going to
lot
be
of good
on with us.
stuff.
So he's going to be a mainstay on these podcasts. So thank you very much for your time, Brad, and we'll chat soon.
Of course. All right. Take care, Michael. Thanks.